Professor Pocar, as you already understood, he plays a very important role in all this because it is actually the idea started in dialogue with him a few years ago. Professor Pocar led this very important project, so-called Progetto Cariplo, for the implementation of international crimes into the Italian system. And so this is why I am really personally very grateful to him for being with us today. Professor Pocar is Emeritus of International Law at the University of Milan. He was for a long time also faculty dean here, and most importantly was the former president and judge of the International Criminal Tribunal for the former Yugoslavia, the ICTY. Before that, he was also an elected member of the Human Rights Committee of the UN. I don't think he really needs much introduction. And thank you again.
Have to press anything, or it goes automatically? Good. Thank you, Chantal, and thank you, Florian, for having organized this this workshop. And take this away now. And for inviting me to this important meeting, which I hope might revitalize the debate in Italy. But let me first thank also the foundation, the Alexander von Humboldt Foundation, which has taken the onus of financing this, organizing this. And last but not least, let me give a final thank to the Foundation Cariplo, because without that foundation, we would not have been able to prepare the document I am now presenting. The Foundation Cariplo is a big foundation that has a lot of money, but does not invest on law, essentially. They made an exception for this project, but say, well, once we can do it. And this was why I could get it. But let me start by saying, taking what Chantal Meloni said at the beginning of her intervention, that is that it's striking that Italy has not adopted legislation. It's striking in one sense, because we know we organized the Rome Conference, we presided, the Rome Conference was presided by an outstanding criminal lawyer, Professor Conso. So we had a big role in adopting the statute, but we also have a tradition not to implement international law easily. So it takes time. Normally it takes time. It's not that we don't implement it, but it takes time. And I remember that more than 20 years ago, in this university, the Faculty of Political Sciences, a workshop was organized that was in honor of Professor Migliazza, who's an outstanding professor of not just of criminal law, but of humanitarian law, essentially. But of course, for war crimes, humanitarian law is important. And it was in his honor when he retired. And it was on war crimes and the competence of national jurisdiction. So it was exactly the problem of international jurisdiction and domestic jurisdiction. The ICC conference had not taken place yet. It was in '97. The ad hoc tribunals, ICTY, ICTR, had started to work, but the statute did not require states to introduce the crimes into the domestic law. It was just an exercise of justice centralized, to take the expression of Professor Hiesberger, centralized, and the states had nothing to do with that except cooperating with the court, cooperating in surrendering the individuals, in getting evidence in case in their countries, but there was nothing else from the point of view, no exercise of jurisdiction by states. Although states could exercise jurisdiction, of course, on the crimes, and there was a rule, I will come back later on that rule, regulating who would exercise jurisdiction, but there was the rule of ne bis in idem. When there is a concurrent jurisdiction, of course, you need that rule in particular to avoid that the same crime is prosecuted twice, or to decide when the same facts can be prosecuted twice. That's more complicated even. The debate at that time was essentially on the implementation of the Geneva Conventions of '49, because the Geneva Conventions contain an obligation of states to exercise universal jurisdiction of violations of the conventions. They constitute, according to the convention, grave breaches of the convention. But of course, the conventions put an obligation on states to criminalize those grave breaches and to exercise jurisdiction, universal jurisdiction over those grave breaches. So Italy had done nothing on that. And in 1997, we discussed that it was a bit too late, 50 years later, not having done anything on the Geneva Convention. We were not alone. So, because many states did not implement the Geneva Conventions, but the problem certainly existed at the time. The obvious conclusion at the time was that Italy should revise the provisions in the Italian law on war crimes. The discussion was only on war crimes. Revise the military code, where some war crimes are established, and adopt a system in consonance, coherent with the Geneva Convention. Nothing was done after that, of course. Other years have elapsed, and nothing happened on the Geneva Conventions, because the occasion of the Rome Statute could be also a moment to put the legislation in line with the Geneva Conventions. I mean, if you create, and to a certain extent, Germany has done it, of course, because war crimes are the same as the grave breaches to a large extent, so you can adopt a system in domestic law that takes into account this. And I remember that in concluding that workshop, then I stopped with that, but it's necessary for what we will say later. I said that the efficiency of the future court that was going to be established the following year could be measured not only on what the court would do, but on what the states would do. Because the system, as was already, we knew from some projects, was a system that was not centralized as the ad hoc tribunals were, but was decentralized or mixed, centralized and decentralized at the same time. So it took the idea from what was the trend at the moment, that it was felt that a centralized system could not be sufficient, in any case. So we needed the domestic jurisdictions as well. This is a long story because it starts with Nuremberg. Nuremberg was centralized, of course, although it had some decentralization with the military commissions that were domestic, because the occupying powers are domestic jurisdiction, technically speaking. So there was some decentralization, but essentially it was a centralized system. The Geneva Conventions were fully decentralized. There was nothing centralized. All the responsibility was put for prosecuting crimes, international crimes, was put on the states, simply on the states. And then the ICTY, ICTI were again centralized, but there was the idea that domestic jurisdiction should do something, and indeed the following courts, tribunals that the Security Council established were no more centralized. They were hybrid, mixed, putting together domestic and international judges, having domestic courts work together with the court that was established. So I concur completely with what has been said now by my colleague Hiesberger, that this is a partnership in which the international community can work on prosecuting crimes, but at the same time, states must work as well. It would be, I think anybody would consider an utopia to transfer jurisdiction on this matter fully to an international court, to a world court. It couldn't work, simply. It would cost too much. You can establish a court with 18 judges, they cannot do all the work, of course. It's obvious. But if you extend the number of the judges, they will do more work, but you can't transfer completely the jurisdiction to the international system. So it's absolutely necessary that there is an interaction between domestic and international jurisdiction. Now, let's come to what was essentially what I had to do, so to present the CARICO project. The idea, as I said, was just to stimulate. We started before the 2012 law on cooperation. We still hoped that it could work, but that law was simply a law of cooperation. By the way, I really like the system that was adopted by Germany in this case, in the case of the court. Because when you have to adopt a treaty that imposes a number of obligations, make a law, introduce the implementation provisions, and then you ratify and don't incur possibly in international liability for not respecting international obligations. It's so obvious, and it's more serious. I understand that there was the idea to ratify immediately because Italy had been one of the engines in the court, and we wanted to arrive first. But what happened? We ratified, but although we did it quickly, we arrived in the first place, so not even to the podium of the ratifying countries. So it was an effort that was not necessary to make, was better to do something else. And to revitalize, we considered, I with some friends, considered that we needed to make, to propose a private example of a possible code of the crimes. We limited it to the code of the crimes, so it was a criminal code that we wanted to establish that could take into account a new system in the law, something as what Germany has done with the code of criminal criminal international code. And of course, the research that we put in place was to propose the crimes that fully implement the statute, but at the same time to take the opportunity to change the Italian legislation and to put it online with new trends, because some of the crimes could be old-fashioned and the legislation could be sufficient to implement the statute, but we noticed also that the statute was not fully online with the new trends, because it's obvious this, because when you go to establish, to create a convention, you go into negotiations with states. And there are the interests of the states that not necessarily are in the interest of what an academic would see in the law. So there have been restrictions that have been made by the Rome Statute as to what could be the customary law on the matter. Customary law evolved separately from all the attempts of creating new instruments. It's a source that proceeds its way. And I make the example of genocide, for instance. Genocide is the crime that did not exist as such in Nuremberg, but although some of the decisions are based on same facts, say they would constitute genocide, but immediately afterwards it was codified. So it was codified in 1948. And it was said immediately afterwards by the International Court of Justice that that codification reflected customary law fully. And this is correct, of course. It was correct. It is correct even today that legislation, that convention reflects customary law. But what is the point? Does it exhaust customary law or not? Even accepting, which is still disputable, that in 1948 customary law had exactly the same content as the convention, which can be disputed still, but even accepting that, can we say today that the 1948 convention exhausts completely customary law? Or there could be other reasons for claiming that under customary law there is genocide. Take, for instance, one of the grounds for genocide is that the group must be ethnic or national, racial, or religious. So it was decided at that time to restrict the kind of groups whose destruction means genocide. But what about other groups? Cultural groups? It was discussed. At the end, it was said no, for reasons that are not very convincing at the time, but states agreed to leave it out. For instance, one of the reasons it was brought is that, well, we should accept that there are primitive people, groups, and that the state is entitled to destroy their culture. That was said. It was the beginning of the colonization, but it was said against cultural genocide. Today, is that something that somebody would dare to say, that destroying a primitive group would not be genocide? So the law, the customary law, goes its way, and not necessarily is consolidated in a treaty. The treaty, by definition, consolidates the law, but customary law is not consolidated. Had the problem been raised before an ad hoc tribunal, I don't know what the decision would have been said. Although the ICTY confirmed the position of the convention. But the problem is that the ICTY had the convention text written in its statute. And if you accept that you have jurisdiction only on the basis of the statute, as it was accepted, you can't apply a law of genocide which is not reflected in the statute. So there was a reason. There was not that reason for the International Court of Justice a few years later, in 2007, when it decided the convention on the dispute between Bosnia-Herzegovina and Serbia-Montenegro. The court could have possibly gone a bit beyond and said the cultural genocide that was raised could be taken into account. But it did not. It did not. It said, it confirmed the position it had taken in 1950, that the customary law was reflected in the statute as such. And so it didn't do anything. But now, in adopting a law in a country, should we take into account of customary law when we discuss of genocide or not? That was one of the issues. How far, I made the example of genocide, but it can be made for other rules. Should we rely on what the statute does, because this is a law on the occasion of the implementation of the Rome Statute, or should we go further and take into account other sources of law, in particular customary law, as far as international law is concerned, or even domestic law, domestic trends. If a domestic trend goes in a different way and further than the Rome Convention, why should the law not codify? The important thing we decided in making our effort was that in any case, the law we were going to propose should have encompassed the statute, inevitably, but could go beyond the statute. And if you look, for instance, the provision on genocide, the provision on genocide goes much further and speaks of other groups as well. Will the legislator in Italy decide to have all these other groups or not? That's a different issue, of course. But as a private tentative to codify the law, we thought we should give all the possibilities of adopting rules. For instance, one of the issues that was discussed already at Nuremberg and was not linked necessarily to the reasons that you find defined in the groups in the Convention of 48 was the vulnerable people. We know that there was, at the time, a destruction of groups that was made because they were handicapped, simply. People that were not able to work, for instance, enough. But is that enough not to say this is a genocide if you destroy that group? We put even that in our effort, in our code, in our possible code. So without expanding the group necessarily to all possible groups that one can find, but we tried to catch the sense of the changes in the society, both national and international, to adapt and take a law that could really take into account all positions. Another issue that we had to consider, but I already talked of it a moment now, is the question of if we should adopt in the law exactly the positions of the statute or change them to a certain extent. Because there is one issue that is more complicated, is the question of the nebis in idem I mentioned. The ad hoc statutes adopted by the Security Council established that, of course, the domestic jurisdiction was concurrent with the international. But in any case, the international had priority. In particular, could not apply the principle nebis in idem if the accused had been tried domestically on the basis of an ordinary crime. So if the accused had been tried domestically and the prosecutor brought an international crime before the court, that would be enough. But if the prosecutor had brought a domestic crime that existed also in the international domain, that was not enough. Take a case of torture, one is convicted for torture and under the ordinary law. There was not in Italy, there was not a case of Italy. In other countries there were laws on torture. Italy didn't have a law on torture, a case, a possible case. But if you have a situation of this kind, the tribunal could say, no, we try again, because torture has been brought as an ordinary crime. And maybe the conviction for torture given by the domestic jurisdiction would have been higher, with a higher penalty than the international one. Does it make sense? The statute, the Rome statute, takes a different approach and says, well, the principle of nebis in idem is set aside only if the prosecutor, it's for the prosecutor to prove that the ordinary law was adopted only to shield the accused. So to find a way of not stigmatizing the crime he had committed. So it puts the burden on the prosecutor to do that. Which means that in adopting a law, it's important for adopting the law, you can not necessarily underline the internationality of the crime in putting it on the law. Oh, I know. You're right. Well, there will be time to raise other issues later on, but this was a point that we had to discuss. But the main point was against, I say, customary law. Now, what we did in each of the sections on genocide, on crimes against humanity, and on war crimes, we have an article, a beginning article with the chapeau element. So the crimes that follow, all of them are regarded as international as well. But in fact, when these conditions are met. But otherwise, you have the crime can be used as a domestic crime, not necessarily as an international crime by the prosecutor in a specific case, if this chapeau element is not met. But we don't need to have two laws, actually, on this point. I can't go, of course, into details. It was just a short presentation of the project. It's a project of 54 articles with commentaries, actually, so it's quite a big document of many pages. But and it's based also on the case law of the international courts, essentially at the time of the ad hoc tribunals in particular when customary law is considered. I stop here, but we will have the opportunity, I think, of discuss other issues of the debate over this meeting later on. I'm sorry I went a bit.
No, you're not.